Hello, everyone. Welcome to Court with Krissy. After suffering through that trial, I don't know about you, but this is the update I have been waiting for. It's sentencing day, and the only favor that attorney Karen does for her client, she appears virtually. She's saving him money. If you happen to miss this trial, there is an entire playlist. Enjoy. I hope you like it. Court with Krissy is now in session.
David Walter Talisman. There are three files: 247158, 247178, and 247184. Time and day set for sentencing in each of the respective files. Mr. Talisman is in the court, represented by attorney Karen J. Davis Roberts, who appears via the Zoom application. People are represented by prosecuting attorney Timothy J. Rakowski. And we had arranged, as Ms. Roberts is from the Saline area, to appear via Zoom. Mr. Talisman, is there any objection to having your attorney appear via Zoom this morning, sir?
No, Your Honor.
Thank you. On June 5th of this year, a jury of Mr. Talisman's peers found the defendant guilty in 7158 of aggravated stalking and using a computer to commit a crime. In 7178, a jury of his peers found the defendant guilty of home invasion first degree, assault with intent to do great bodily harm less than murder, and interference with electronic communications. Finally, in 7184, the defendant was found guilty by a jury of his peers to home invasion second degree and unauthorized access to a computer. As stated, this is the time and date set for sentencing. Ms. Karen Eberlin has prepared the pre-sentence report. It's dated July 7, 2025. First, Ms. Roberts, have you and your client had the opportunity to review the pre-sentence report?
Yes, Your Honor.
Other than guidelines, and the court's aware there are objections to the guidelines, which we'll address in a moment, just the body of the report in and of itself, are there any additions, deletions, corrections, or objections to the report other than guidelines? First, Ms. Roberts.
A couple of corrections, Your Honor, and I will go through them. The first is on page 2, where it talks about each one of the cases, and it talks about sentencing details and credit for time that he's already served. And that is on docket number 24307-184FH. It says that he only got credit for 245 days. My question is, this was all out of the same set of circumstances, and so I don't know why he only got credit for 245 rather than the others at 293.
Mr. Rakowski.
He didn't get credit because he wasn't charged. He got credit from the day he was charged, which is 245.
So it had to do with the fact that then the prosecutor just didn't charge it till then, even though it was out of the same set of circumstances. Shouldn't it be at the same credit for the same amount of days?
Any comments?
My comment is he was not charged. He was not charged on that. FedEx was doing an investigation, completing that. They had things to take care of before we could actually charge that. So that's why it's 245.
Okay. Anything else regarding that, Ms. Roberts?
Not regarding that, but on the...
All right, well, I'm going to make a ruling on it. That's indeed the charge, and the court finds that 245 is the correct time, and that will remain the same. Go ahead, Ms. Roberts, with your next issue, please.
On the evaluation and plan, actually, I'm not sure why I did that. I'm sorry. That's incorrect. Page 2, it has to do with the pre-sentence investigation under the compass chart, COMPAS, like Sam, it says family criminality, highly probable. I don't see that that's based on anything that I've read in the report. So I'm curious as to why that was put in there.
In that case, I'd have to ask Mr. Licht. Mr. Licht?
Everything that comes from the compass comes from the packet that the defendant, we issue them a packet, they fill out a bubble sheet, and that's how it's input in the computer. Gives a certain results of strengths, weaknesses, and areas. Like in this instance, it was highly probable. It's all off of what Mr. Talisman filled out in that compass assessment packet at PSI.
So, are you able to hear that, Roger?
Yes. So in other words, but that will be assessed also when he gets to Jackson. Is that correct?
That is correct.
All right. That's fine. Then I'm satisfied with that answer, Your Honor.
Okay, thank you. Anything else regarding the report other than guidelines?
Yes, there's a couple of other things, Your Honor.
No, go ahead, please.
Page 3, I think there are a couple of errors. In the first paragraph, the fourth line, it states that Shauna and Dave had broken up 6 months ago. And then on the second paragraph, it says that they had been broken up for 3 months. That's the second paragraph, the 7th line. And that would be for probation.
All right. Well, the first statement comes from Daniel, and the second statement comes from Ms. Lavalette. So I'm assuming, and I could be wrong, Mr. Rakowski can correct me if I'm wrong, but those are 2 different accounts from 2 different individuals, correct?
That's correct, Your Honor.
Okay. Thank you for the explanation. On page 6, the last paragraph, I'm sorry. One, two, three, four, 6. On the 7th line, it says the last physical incident happened on March 12th, where they were arguing and began pushing each other, causing her to fall awkwardly. I think the evidence said that, and she went to kick defendant, is when she fell.
Mr. Rakowski, any response?
Well, it's the information she provided to the police. It comes from the police report involving Sergeant Flores. That's where that information comes from.
What's the issue with that, counsel?
Just that I think that's an incorrect statement.
I'm assuming, Mr. Lick, this comes directly from the police report as well.
It does.
Okay.
Finally,
It states.
thank you. Finally, on page 13, and I don't know if this is possible, it talks about his family and marriage, significant others. Mr. Talisman would like Winnie Carl to be removed as a significant other, if that's possible. And that would be it.
Where is that listed?
Page.
Oh, I see it under marriage.
Yes, sir.
And what's the reason for the request for removal, counsel?
Mr. Talisman would just like to have it removed. During our discussion, he asked if it can be removed. He would like that.
Mr. Rakowski, do you have any position on that?
We have no position on that.
I'm assuming he reported this, though, to your department.
Last sentence of David reported he was involved in a relationship with Wendy Carl.
It stays. It stays over objection.
Thank you, Your Honor. And that would be all of the corrections, additions, or deletions that need to be made.
Thank you. Mr. Talisman, is there anything else your attorney didn't mention regarding the report itself? Not the guidelines, but anything else regarding this report, sir?
There was a case number incorrect on one of the paragraphs. In reference to the aggravated stalking, but the case number referenced the home invasion too.
You have any idea what page that might be on?
I'm not sure, but the case number, like third paragraph, but it's the very first paragraph.
Let's take
I guess within the first sentence.
Counsel, do you have any idea what he's referring to regarding the page?
No, unfortunately, I don't. And I had thought I had taken down all the notes.
Your Honor, I may be able to shed some light.
Mr. Bahani, go ahead.
If the court recalls, there were multiple counts originally of aggravated stalking across these three files. The people filed a motion to amend the information just prior to trial, where one count of aggravated stalking was consolidated with all counts in the current case number. So the reference that is made in the report could refer to one of the case files that originally had another count of aggravated stalking that the people consolidated. That makes sense.
That makes sense to you, sir?
Yes, but on the charge sheet, the number matches the home invasion 2 only, to where what they discussed in the paragraph is the aggravated stalking and the computer crimes.
The computer crimes case, Your Honor, originally had a count of aggravated stalking attached to it that was consolidated in, I believe, 184.
Okay. It'll remain the same. Anything else, sir, other than what you stated?
No, sir.
For your turn.
Your Honor.
All right, Mr. Rakowski, any objection to the report?
No.
And you objections to the guidelines as well, right? Or at least, you responded to.
Yes, sir.
No objection to the scoring of the guidelines. But Ms. Roberts does have objections, and I believe it begins with OV3. Is that correct, counsel?
Yes, Your Honor.
You may proceed.
I've had an opportunity to review the answer that the prosecutor has provided. However, I disagree with their calculations. On OV3, they believe that the scoring is correct at 25 points. However, Your Honor, and I repeat, as I did in my objections, that the contusion that Mr. Stevens sustained was only a 2x4 millimeter. That's incredibly small, and it was a contusion. It's similar to having a bruise on your arm or your leg. It was not life-threatening. He only had an overnight stay at the hospital. I don't recall any testimony by Dr. Blaker regarding the fact that it was a life-threatening injury. There may have been some testimony by Dr. Blaker stating that injuries like this could be life-threatening, but there was no testimony regarding the fact that Mr. Stevens' injuries were, in fact, life-threatening. There was no incapacitation by Mr. Stevens. There was no, lasting injury. And There were no issues with his activities of daily living. The case law supports only assessing 10 points to that.
Mr. Rakowski.
Matter, we believe it was properly scored by the Department of Corrections at 25 points. As it indicates, it's life-threatening or permanent incapacitating injury occurred to the victim. In this case, the victim was taken to McLaren Thumb here in Bad Axe. Dr. Blaker had run some tests, had some things done, found that there was a brain bleed. They're not capable of handling that up in Bad Axe, so he was transferred down to Lapeer. He would not have been had it not been something that was potentially life-threatening. And that's what Dr. Blaker's testimony was at trial. Brain bleeds are significant and potentially life-threatening injury, and that's why he was sent. Had it not been for that, he would not have been sent. But there was a brain bleed. Now, we're fortunate that Mr. Stevens recovered, but that's not what the guidelines are looking at, what it is. Was it potentially was life-threatening? And we would argue that it's life-threatening, given the fact that he was transferred down to be seen by neurology down there because they had to take care of that and address Mr. Stevens' condition.
Thank you. Rebuttal argument?
Your Honor, yes. Anything can be potentially life-threatening when it comes to an injury. If you get scratched on your hand, technically it's potentially life-threatening in that it can become infected. The guidelines do not, nor does the case law, discuss whether or not it could be life-threatening. The case law states that it was life-threatening. And in this case, it was not life-threatening and should be assessed at 10 points.
Anything else?
No, Your Honor.
Okay. Under all the offense variables for scoring of the guidelines, preponderance of the evidence standard applies. And as a result, the court is to consider in part, well, not in part, but consider the testimony presented at trial, any exhibits that were admitted, and review the pre-sentence report as well. And the court recalls the incident in question. This would have been in the Sanilac County case. It's Huron County, but charged in Huron County. The injury sustained to the victim in this case, which indeed was a brain bleed. There was no question about that. And there was a point in time where I recall testimony of the other individual in the home, and she testified that either stopped breathing or gurgling or making noises to indicate we have a serious problem here. There's also a point in time where the victim had no recall of the event, if I recall correctly. And as a result of the strike or the blow, obviously medical treatment was provided to the victim in this case, based upon the testimony from the doctor at, I would have said Huron Medical Center, but that's old, at McLaren Thumb Region. It was not the type of basically treatment that could be provided by that particular hospital. It was indeed a brain bleed. He was transported to McLaren Lapeer, where he was treated for his injuries in this case, and obviously successful treatment. And as a result, the victim is still with us here today. But when you consider that and the type of blow that was sustained in the head area as well, this court finds that it is not a potential life threat. It was a life-threatening type of issue based upon the strike and the blow upon the victim. 25 points is the proper scoring. The objection is overruled relative to OV3. I believe we go then to OV4, correct, counsel?
Yes, that's correct.
Go ahead, please.
It has to do with psychological injury. There was no testimony at trial, nor was there anything provided to probation regarding testimony about how his family is taking this hard. Mr. Stevens, during the trial, did not state he had any memory issues other than which was immediate. There's no evidence regarding his inability to work or to carry on his life because of continuing emotional or psychological issues. There was some mention of blood on the carpet, regarding the event. I would hope that at this time it has been washed up. I mean, it's been over a year, but that has nothing to do with his psychological state. I do not believe that the case law supports 10 points for this assessment.
Thank you. Mr. Rakowski.
Responding, we believe the Department of Corrections scored this OB4 at 10 points correctly. So you have Mr. Stevens, who's in his house on a weekday and watching a movie, and you have the defendant come over to his house, come into his house. Mr. Stevens has to barricade himself in his bedroom. The door is beaten off. The court saw the evidence through photographs where the screws are still on the hinges, and there is just all kinds of blood in the bedroom. The damage, the dresser tipped over, holes in the closet door that was there. So when Miss Stevens says, well, I hope he cleaned it up, and that should be that. I mean, he's living at this place, and he knows what happened to him. So we provided the court the victim's impact statement. It's listed off, I believe it's page 8. It starts on to page 9. And Mr. Stevens indicate he ran into my home, beat down my door, continued to hit me in the head. I spent 2 days in McLaren and Lapeer, brain bleed, lack of memory. My family is taking this just as hard as I am. The next quote, hit me in the head and face to the point where I had a brain bleed as well as my skull. My carpet still has blood stains on it. Then the next quote, he destroyed any form of casual relaxation in my home. My family is scared. The matter is mediated, and he is a danger to anyone. So, as far as the defendant counsel said, well, there was no proof at trial. There's information provided at trial. This also buttresses the psychological injury portion for the guidelines. You don't have to produce all that at trial because that's not always necessary. The court has to, as it said earlier, by a preponderance of the evidence, determine whether there's information. And here, there was information provided through the victim's impact statement.
Ms. Roberts, any other arguments?
None, Your Honor.
Thank you. Again, the same standard applies regarding preponderance of the evidence relative to the offense variables. Psychological injury to a victim, 10 points is scored if serious psychological injury requiring professional treatment occurred to a victim, citing MCL 777.34 parens 1 parens A. And in the instructions, it indicates score 10 points if serious psychological injury may require professional treatment. In making this determination, the fact that treatment has not been sought is not conclusive, citing MCL 777.342. In this case, it's clear there was no testimony elicited at trial regarding any psychological trauma regarding professional treatment. So the trial is absent relative to that. However, the court is allowed to review victim impact statements as well. And when you look at the victim impact statement and you look in the description of the injuries and the blood on the carpet, I think what's really significant is he destroyed any form of casual relaxation in my own house. Now he says my family is scared, but he destroyed any form of casual relaxation in my own home. Well, that to me indicates psychological injury. It also indicates serious psychological injury when you buttress that with the injury sustained as well as the lasting impact. So I find OV4 is properly scored. The objection to modify OV4 from 10 points to 0 points is respectfully denied. OV7, please.
Yes, Your Honor. That has to do with sadism and torture and excessive brutality. The damage in the house that the prosecutor talks about was due to a fight between two grown men. Of course, there's going to be a lot of damage. It makes sense if they're falling into different things. but it has nothing to do with the assessment of 50 points. The prosecutor also described the fight as a savage beating. My interpretation is diametrically different than that. It was a fight. It wasn't a savage beating. There was no sadism. There was no torture. There was no excessive brutality, and there was no egregious conduct. Of course, the prosecutor has also included a video of my client lifting weights with a cast when he had his cast on. Um, that has nothing to do with the fight, and that kind of lifting would be to work on uh, the leg muscles and nothing of the upper body. The strongman competition that Mr. Talisman was involved in was in 2017. That was the last time he competed. That was 7 years before this. A lot of things change in 7 years. And Mr. Talisman was no longer competing. He did not subject the victim to excessive or extreme pain or an extensive and serious injury. Again, I do not believe, nor do I believe the evidence has shown that it was a life-threatening injury or that it was somehow excessive brutality. As I've explained in my objections, the case law does support our objection to this being scored at 50 points, and should be scored at 0.
Thank you. Mr. Rakowski, your response.
Your Honor, we would argue that OB7 was properly scored by the Department of Corrections at 50 points. As it relates to OB7, what we look at is it's either 50 points or 0. And Ms. Roberts has indicated correctly that the victim you have to have for 50 points was treated with sadism or torture or excessive brutality or similar conduct egregiously designed to substantially increase the fear and anxiety of victims suffering during the offense. So when you look at the scoring of OB7, say, what do we have by way of proof that this was either excessive brutality or similarly egregious conduct substantially to increase the fear and anxiety of the victim? Now, Ms. Roberts had mentioned about these videos that we provided to the court about the strongman competition and working out with his cast on. And partly that isn't due to her objection, because she argued at trial and she argued during her objection that, well, Mr. Stevens is taller, he's heavier than the defendant, and the defendant is basically just defending himself. And we would argue that's not the case. He's a strong man. He was in a strongman competition. So then, well, yes, that might have been 7, 8 years ago. And then there's other weightlifting and 4 years ago based on these videos that was on YouTube. But, you know, it was nothing recent. Well, when they searched Mr. Talisman's phone, they found the video of him doing leg presses with his cast holding up the bar as he's doing these legs. So he's physically fit. And I would argue much more physically fit than Mr. Stevens at the time. And so we say, okay, well, just because he's physically fit, does that mean that it's excessive brutality or egregious conduct to substantially increase the fear and anxiety the victim suffered for the offense? Well, you have to also compare it to the testimony, because the testimony from the other act's evidence, in part, was December of 2023, Mr. Stevens showed up at his house. And I believe the testimony is somewhere around December 5th or 6th of 2023. The defendant shows up to his house, and when Mr. Stevens pulls in the driveway, he said the defendant's already there. He comes over, Mr. Stevens has his window down, and the defendant leans into his vehicle, and during the conversation tells him to stay away from Miss Laviolette, because if he had to come back, it wouldn't be good for Mr. Stevens. And I would argue to the court, he was sending that message back then. And then when you look at all the evidence that was presented at trial, how he went in the house, all the damage that was caused, and the injuries to Mr. Stevens, he clearly was sending a message, you'll stay away. And he beat him savagely to send that message home to Mr. Stevens for the future. And he could have committed the crime of home invasion and the assault to do great bodily harm without having to inflict as much damage and pain on Mr. Stevens as he did. And that's why he scored 50 points.
Ms. Roberts, rebuttal argument.
No rebuttal.
Thank you. OV7 again applies the same standard, preponderance of the evidence. That is under the caption of aggravated physical abuse. The department has scored 50 points in this matter. And Mr. Rakowski is correct. It's either 50 or 0. And it indicates a victim was treated with sadism, torture, excessive brutality, or similarly, I can never say that, egregious conduct designed, that is, to substantially increase the fear and anxiety a victim suffered during the offense. Again, this was a home invasion 1, and the court recalls the testimony at trial, and this was disputed by the defendant when he took the witness stand, because once the defendant took the witness stand, he had testified that the victim swung at him first and that he was merely defending himself. And if I recall correctly, the law of physics was kind of thrown out the window at that point because it was either falling backward or falling forward. If the victim applied the first blow or attempted to, you would suspect that the defendant would be falling backward. He fell forward into the residence. So it appears to the court, and the jury accepted that relative to their findings in this case, that the defendant not only threw the first punch, but struck him in such a manner that caused a brain bleed. And that's not the end of it, because it is true. This was brought out by the victim during his testimony at trial sometime in December prior to this incident. If I recall correctly, the victim arrived at his home, saw a vehicle on his property. Was it maybe just the opposite? Well, regardless of the circumstances, the defendant was there. The defendant leaned in to the open window of the victim and basically gave him the ultimatum, stay away from Ms. Laviolette, and if you don't, bad things are going to happen. The defendant showed up to the victim's residence months prior. And that appears to the court, based upon a preponderance of the evidence, to be sending a message. Don't be messing with my girlfriend, in essence. If you do, then something is going to happen. And that would put someone in fear. Not only in fear, but again, it looks at, it's not sadism per se. Well, no, I'll back up. Sadism is defined conduct that subjects a victim to extreme or prolonged pain or humiliation and is inflicted to produce suffering or for the offender's gratification. It appears to be a form of sadism, one, but more importantly, it is designed to substantially increase the fear and anxiety of a victim suffered during the offense. So much weaker regarding sadism per se, but similarly egregious conduct designed to substantially increase the fear and anxiety. The warning shot was fired. Either you stay away or something bad's going to happen to you. Drove to the victim's residence for that purpose. Court finds OV7 is properly scored at 50 points over objection. OV19, please.
On OV19, the fact that the defendant told the police a different story does not provide the basis for the 10 points which were assessed. There's no actions that actively redirected the investigation. There was no attempt to conceal any of the evidence. There was no attempt to prevent witnesses from testifying. There was no attempt to successfully prevent the police from being able to arrest him. And that's under People versus D word. Let me spell it. D like David, EWEERD. That's at 511 Mish 979 at 2023 case. OV19 should be at 0.
Thank you. Mr. Rakowski.
Your Honor, this is OB19. Originally, the argument in writing from Ms. Roberts was that it was improperly scored at 10 points because they used the violation of the personal protection order. I believe it, the language, the operative language for it says 10 points can be scored if there was a direct or indirect violation of the personal protection order. Well, we do have that here, but our argument and what I put down in writing more focused on the lying to the police officer, because clearly when the defendant testified at trial and the court got a chance to watch the statement that was taken by the police, there were so many lies in the statement to the police compared to the defendant's testimony at trial. So,
such as,
so some of them would be during that he said he'd never been to Mr. Stevens' place before. Well, we know that that wasn't true based on the testimony of Mr. Stevens that he was there earlier. One that I pointed out before was the officer says to him, the messages, you were sending messages up and back? Yeah. What kind of messages were they? Oh, they were just lovey-dovey stuff. So there's nothing going to be angry or threatening? No, not at all. And we kind of went through those, Your Honor, as far as what those messages were. And I would submit to the court, because the court got a chance to see them when they were presented. They were not lovey-dovey messages. You know, he said he also was at Walmart. We know that when Detective Deakins had testified, he went through the defendant's phone and it shows different locations, never at Walmart on that day as well. Talked about how he fell into the house, which we would argue is not the case. And then when Detective Flores asked him, this would be the morning of the 3rd of July, said, hey, you know, the Santa Clara County Sheriff's Department would like to talk to you. Do you know what that's all about? No, I have no idea whatsoever. He'd just been involved in a physical altercation. Whether or not his statement to the police would have been, hey, it was a fight, but I was attacked. But that wasn't the case. So I have no idea as to why. These are all lies that I've highlighted for the court. But I think when you compare what his testimony was to the statement taken by Detective Horst, as well as the statement he gave to Sergeant Flores, that he lied. And as a result, we cited People versus Barbie, which talks about deceiving the investigation. This court has been consistent on that in the past. As the court has properly said in the past, a defendant has the absolute right not to say anything. But if you say something to the police, then you must be truthful. If you're trying to deceive, then OV19 gets scored. And we believe it's properly scored at 10 points.
Thank you. Ms. Roberts, any rebuttal argument?
None, Your Honor.
All right, thank you. OV19 is scored at 10 points if the offender otherwise interfered with or attempted to interfere with the administration of justice or directly or indirectly violated a personal protection order, citing MCL 777.49C. Well, there was a personal protection order, but at the end of the day, it really comes to the defendant's behaviors after, frankly, when he was interviewed by police. And there's no question that his trial testimony was different than what was stated to the officer in the investigation. And it's true that the defendant acknowledged he had never been at that residence before, but he was. And I recall, because this was, I believe, the defendant's statement. It's not maybe verbatim, but the texts were lovey-dovey. They were not lovey-dovey by any stretch. The defendant also stated that he was at another location. Police had to pull video, look at cell phone records to determine whether or not that was the case. It wasn't the case, so there was deceit there. The court also recalls testimony that the defendant stated that he went to the residence that evening to pick up grass clippings at 9 o'clock at night, which doesn't make any sense to the court. OV-19 is properly scored at 10 points. The objection is respectfully denied. As a result, and there are no other scoring objections, correct, Ms. Roberts?
That's correct, Your Honor.
All right. Guideline ranges in this matter are calculated in 7158 at 19 to 38, 78 file 57 to 95, and an 84 29 to 57. Ms. Roberts, anything you'd like to say on behalf of your client before the court imposes sentence?
Well, Your Honor, I would rely heavily on my sentencing memo, but in addition to that, this is the first time that Mr. Talisman has been in trouble with the police of any significance. The minor in possession and disturbing the peace were minor scrimmages, and one was in 2019, the other was when he was less than 21. Considering all that, I'm asking the court to impose a sentence at the low end of the guidelines. This is unusual behavior. He's been lifting for years. He's competed in strongman competition and has never, ever used that to his detriment. Unfortunately, that happened in this instance. Considering all that, a sentence at the bottom of the guidelines, Your Honor.
Thank you. Before I ask if your client wishes to address the court does acknowledge the sentencing memorandum that was submitted to the court. Also, the court reviewed letters from Torrey, T-O-R-R-E-Y, Ahrens, A-H-R-E-N-S, a letter from Becky Booms, a letter from Tina Marsh, a letter from Angela O'Connell, a letter from Kelsey, K-E-L-C-Y, Beck, B-E-C-K, Paul Backus, B-A-C-K-U-S, Winnie Carl, W-I-N-N-I-E-K-A-R-L-E. So the court has considered that as well. Ms. Roberts, in light of the finding of the jury in this case, does your client wish to address the court?
I believe he does, Your Honor.
Okay. Sir, what would you like to say?
I would like to apologize to the victim that my actions have caused negative effects on. And I would also like to apologize to my family and my daughter. And I plan on using this time to seek better mental health classes and continue my sobriety. So,
thank you, sir. Mr. Rakowski, on behalf of the people, this is a victim's rights case.
Victim wishes to address the court, Your Honor.
Very well, thank you. Sir, would you please state your name?
Dan Stevens.
Mr. Stevens, spell your last name for us, please.
S-T-E-V-E-N-S.
Thank you. Mr. Stevens, what would you like to tell the court, sir?
Dave, it's been over a year since he came to my house and assaulted me. And I was already going through some of the worst years of my adult life because I made poor decision after poor decision. I kept making these poor decisions because I cannot let go and move on from things. I'll hold on to emotions, thoughts, feelings, and my life kept getting worse by my own doing. For most of last year, I felt nothing but disdain for you. But as time went on, I started realizing that I need to let go and move on from that. Those feelings, those emotions are not making my life any better. They were holding me back from closing this chapter in my life. With that being said, in order for me to move on for this, I want you to know that I do not hate you. I do forgive you what you did. I forgive you so that I can keep living life and growing, not holding on to any negative, hateful feelings. And I truly hope that you get the help that you need moving forward. Thank you.
Thank you, Mr. Stevens. Mr. Rakowski, on behalf of the people.
On behalf of the people, the court, we've kind of gone through a lot of this during the arguments of the sentencing guidelines, but I wish to highlight a few things. As far as the case goes, so we have Mr. Talisman, who goes over to Mr. Stevens' house because Miss Laviolette's there and commits the crime, which the home invasion first, the assault and great bodily harm, the interfering with the electronic communications, as well as the fact that he has contact with Miss Laviolette there. How did he get there? Well, he got there because the home invasion second case, where he went into her house in Bad Axe, accessed her iPad, and found her location, and then they could track Mr. Talisman's phone when it goes from Bad Axe all the way down to Mr. Stevens. So that's how he got there. And then the next day, he's stopped because he goes back to Miss Laviolette, sees her outside. They have a brief conversation about some DVD, and then he drives off because she calls the police. I think some of the things to highlight is how severe the injuries were and the damage to the bedroom. So you work your way through the house. There's a table overturned and a chair or a couple chairs in the dining room as you get into the victim's house. And then you go into the living room and there's more damage. A shelf pulled over, glass broke, some other things tipped over. And then you go to the bedroom, whereas the court heard during the testimony, Mr. Stevens has barricaded himself in there because he already had Miss Laviolette, told her to go back there. And the door is tore off its hinges. You've got the closet door that had the punch holes through it, and the dresser's overturned, and then this amount of blood, copious amount of blood on the floor under the clothes. And, so that was a really, really significant circumstance. Individual has a right to be safe in their own home. Their home is their castle. And Mr. Stevens is in his home watching a movie when this defendant comes over there, because as we indicated in our argument earlier to the court, he sent him a message, leave her alone. And I think if you take into account also Mr. Talisman's behavior with Miss Laviolette, because there was testimony from her in this circumstance in October of 2023, where she's in Belleville with some, I think it's Dylan Kennedy, and the defendant comes over there and follows her into the room, however, gets into the room where she's at with Mr. Kennedy and puts Mr. Kennedy up on the wall and tells him to leave her alone. And the other things that are of significance there is he let the air out of her tire, unhooked her battery cable. Why'd you do that? Well, I wanted to make sure I had a chance to talk to her. And of course, as a victim, and I would argue to the court, psychologically abused by this defendant, she went right along with him back when they went home that day, separate vehicles, but she followed him back because of the circumstance. They say, well, he's turned his life around. He's on the right track. So what do we know? We also supplied to the court this video from the jail not that long ago, since he was remanded to custody of the sheriff, that he gets into a fight with Mr. Williams at the jail. And the video shows that Mr. Talisman was the aggressor. He's on the opposite side of the room, comes over to where Mr. Williams is, and they get into a fight for quite some time, to the point where Mr. Talisman is injured. I point all this out because when the court is fashioning a sentence, we're asking for the sentence at the high end of the guidelines because Mr. Talisman is a danger. He's a danger to anybody and everyone based on his attitude and his temper. And because of that, I see the Department of Corrections for the home invasion charge had requested the court consider a sentence of 57 months. Well, the guidelines for that one are 27 to 50 months, 57 months. So that's the high end of the guidelines. And the same thing for the other offense for the assault through great bodily harm. When it gets to the home invasion first, the guidelines are 57 to 95, and the Department of Corrections has recommended 60 months, 5 years. We would argue to the court that that's not appropriate in this case based on the circumstance, and we ask you impose the 95 months on that.
Well, the court had the opportunity to hear the testimony at trial. And we have an individual who, frankly, is young, 36 years of age, has no prior record to speak of. Vocational, high school vocational education, appear to be successful, things going well. But when it comes to letting go, it's hard to let go. And I'm not going to pass judgment upon Ms. Laviolette in this matter, but there was some sort of relationship with Ms. Laviolette that obviously didn't work out well. She was with another individual. Mr. Talisman took it upon himself to basically take control of the situation. It's indeed what he did. And it's not the first time he's done it. It's the second time he's done it, according to the testimony. Tracing someone to a hotel room, I believe in the Metro Detroit area, could be wrong. Finding out where that person is, going into the hotel room, putting the gentleman against the wall saying, stay away from her, unhooking her battery cable, taking air out of a tire. That's a matter of control, domination. I'm in charge. No one else is in charge. You do what I say. That's not the type of relationship that I think anyone should be involved in. So we have that, and then we get to the day in question here. That is the home invasion occurring within a mile of the Huron County border in Sanilac, where the defendant knew where, or I mean, according to the testimony, he was there before, knew exactly where Mr. Stevens and Ms. Laviolette were, went to the address, basically knocked on the door. Mr. Stevens answers the door, and the first thing that happens, there's a blow from the defendant. And if you looked at the photographs of the residents, of pretty much everything being overturned, doors off hinges, closet doors removed, punched into, laying on top of a bed, the blood. That's an individual that is very, very angry, extremely angry, and dangerous, because the defendant, and you can say a 2 millimeter by 4 millimeter is a small brain bleed, contusion, however you want to call it, but he hit him hard. By surprise, the victim tries to barricade himself into his bedroom. Ms. Laviolette is told to hide in the closet. And that door gets ripped right off the hinges. And then we have the fight. To the point where the victim has a point, I'll just call it amnesia, where there's a point he just blacks out, doesn't know what's going on. Ms. Laviolette describes it either as he's talking in a different fashion, or he's mumbling, or he's gurgling. And that tells me someone who's very, very angry. To the point where he drove all the way from Bad Axe to Bay City Forestville Road. And then the next day, he's back at Ms. Laviolette's home in that area again. It will be the sentence of this court relative to the aggravated stalking in this matter, that the defendant be committed to the Michigan Corrections Commission and placed in the commission's custody for a period of 36 months to 5 years, credit for 293 days served. He's also to pay crime victims assessment of $130 and state cost of $136. As to count 2 and 7158, computers using to commit a crime, this was the method of looking at Ms. Laviolette's iPad and finding out where she's at. Same sentence, 36 months, in this case to 7 years, credit for 293 days previously served. 7178, home invasion first degree, guideline range in this matter, 7 to 95 months. Will be the sentence of this court, and the maximum under the guidelines would be 7.9 years. My calculation is correct. Will be the sentence of this court. The defendant be committed to the Michigan Corrections Commission and placed in the commission's custody for a period of 6 years to 20 years. Credit for 293 days served. And I'm not sure. Well, let me. There's also restitution, the amount of $11,766.38, of which $2,288.19 Daniel Stevens, $9,478.19 to Fremont Insurance. Defendant is to execute a wage assignment to pay the restitution if he's employed and misses 2 regularly scheduled payments. Crime victims assessment of $130, DNA testing of $60, and state cost of $204, which will cover all 3 counts. Mr. Lick, can I even order condition 4.5?
I don't believe so.
I don't think so either.
That's something they'll take care of at the time of parole.
Thank you. Count 2, assault with intent to do great bodily harm less than murder by strangulation. The sentence of the court would be 57 months, 10 years, credit for 293 days served. Interfering with electronic communication, defendant shall serve 11 months in the county jail, credit for 293 days served. Finally, in the home invasion second degree, this is 7184. Sentence will be 57 months to 15 years, credit for 245 days served. Crime victims assessment of $130, state cost of $136. Count 2, using a computer, unauthorized access, again, 23 months, I should say again, 23 months to 5 years, credit for 245 days served. These shall run concurrently with each other. By duty to inform the defendant he has absolute right to appeal his convictions in this matter. If he's financially unable to provide counsel of his own choice, the court will assign counsel for him at public expense. He is to initial the receipt for the questionnaire form and for the form providing or requesting the appointment of counsel, both of which must be executed under oath and filed with the clerk of the court within 42 days.
I just need to clear something. Yes. You said number 7 months and we count through 11 months.
He's actually to serve 330 days in the county jail.
Okay.
330.
330.
Yep, 330.
For a minimum and maximum.
No, that's a straight jail sentence.
3 weeks.
330.
330.
330.
Okay.
That'll be all.